Imagine someone owes you $4,000. The unpaid debt is large enough to seriously hurt your finances, but if you try to hire a lawyer to recover it, their hourly legal fees will quickly consume the entire amount you are trying to collect. Small Claims Court is a rapid, low-cost legal track built specifically to solve this exact problem. It allows everyday citizens to present their case directly to a judge and bypass expensive attorneys entirely. As you can see in this breakdown, the legal system is split into two halves. Criminal law is about the government punishing offenses with jail time. Small claims falls strictly under civil law. This side of the system is entirely about resolving private disputes and recovering monetary damages. Nobody goes to jail in a civil suit. Before you file, your case must meet two strict prerequisites. First, you must be suing for a specific fixed dollar amount. Second, that amount must fall under your state's maximum limit, which usually caps out anywhere from $5,000 to $10,000. Understanding this basic framework gives you a direct legal pathway to enforce your financial rights without being blocked by traditional legal gatekeepers. Your first official move is to send a formal demand letter. This document must explicitly state the exact amount of money you are owed, why you are owed it, and provide a hard deadline for payment. Sending this letter fulfills a mandatory legal requirement to show the judge you tried to resolve the issue in good faith. Give the person 14 to 30 days to respond. Often, the reality of a looming legal deadline is enough to secure your payment without ever filing a case. If the deadline passes and they still refuse to pay, you move to the physical filing stage. You will go to your local county court, fill out an official complaint form detailing your claim, and pay a small filing fee. At this stage, accuracy is critical. You must make sure you are suing the exact legal entity that owes you. A local storefront might have a casual name on its sign, but your paperwork must identify their officially registered LLC or corporate name. By submitting this specific form and paying the fee, your casual disagreement transitions into a formally recognized legal dispute backed by the authority of the state. Now you have to notify the person you're suing. The U.S. Constitution guarantees due process, meaning a defendant has an absolute right to know they are being taken to court. In the legal system, this notification procedure is called service of process. You cannot physically hand the lawsuit to the defendant yourself. You must use an approved, neutral method. This means sending the official documents via certified mail or paying a registered process server or local sheriff to deliver the papers in person. If you skip this step or execute it incorrectly, the judge will reject your case immediately. As this stamp shows, failing to properly serve the defendant results in an automatic dismissal. In the eyes of the court, a perfectly argued case with flawless evidence means absolutely nothing if the rules of due process and notification are violated. With the paperwork filed and served, you need to prepare your raw evidence. Gather chronological text messages, signed contracts, repair receipts, and photographs that prove your claim. Next, you must physically organize these documents for the courtroom. You need to create 3 identical evidence binders, one containing the originals for the judge, one for the defendant to review, and one for yourself to reference during the trial. This physical preparation is essential because you carry what is called the burden of proof. Because you brought the lawsuit, it is entirely your responsibility to prove to the judge that your claims are true. However, in civil court, the standard you must meet is called the preponderance of the evidence. Look at this scale. You do not need absolute certainty. You only need to tip the scales to 51%, proving that your version of events is more likely to be true than not. Criminal trials require proof beyond a reasonable doubt, and near absolute certainty that reaches roughly 99%. Small Claims Court leaves that extreme standard behind. You are only aiming for that highly attainable 51% mark. Victory here does not require a Hollywood-style smoking gun. It merely requires being slightly more convincing and better organized than the opposition. When your court date arrives, present your facts in chronological order. Stick strictly to the timeline of events, avoid emotional interruptions, and let your organized evidence do the heavy lifting. If you present your case well, the judge will rule in your favor. But you need to prepare for a harsh reality. When that gavel falls, the judge awards you a legal judgment. They do not hand you a physical check. If the losing defendant still refuses to pay you after the ruling, you must initiate post-judgment enforcement. You are now a legally recognized creditor, and you can petition the court for permission to aggressively seize their assets. The two most effective tactics for this are bank levies and wage garnishments. A levy allows you to instruct the local sheriff to freeze the defendant's bank account and directly withdraw the funds you are owed. Alternatively, a wage garnishment forces the defendant's employer to route a portion of their regular paycheck directly to you until the debt is cleared. Winning the judgment grants you the state's authority to collect, but the ultimate responsibility of tracking down those assets and enforcing the payment still rests squarely with you. We have walked through the complete sequence. You start with a frustrating personal dispute, issue a formal demand, file a complaint, serve the paperwork, meet the 51% burden of proof, and secure a state-backed legal judgment. The civil justice system is intentionally designed to be accessible. It provides a clear set of rules so individuals can navigate a dispute and enforce their rights without relying on expensive legal representation. If someone is holding your money hostage, stop waiting for them to do the right thing on their own. Take your first concrete step today and draft your initial demand letter. Taking immediate, organized legal action is the only definitive way to turn an unpaid debt back into your own money.